Yes.
The hearing matter. I mean, moving around for the last 2 years, Lord. What has happened, Lord? This is regarding promotion of a Group D staff in a subordinate court. Lord. He has been rejected, Lord. He has been denied promotion to the post of LDC. Lord, what has happened, Lord? There are none. Lord, just a second, I just want to go through once.
For inclusion, Acharya.
Yeah, there is no inclusion, Lord. What has happened? He has been denied promotion only on the STSC post, and non-STSC post has been converted to an STSC post. That is difficult. That's all.
Readings are complete. Readings are complete.
Readings are complete.
See, the problem is that we might see a slight more change in the roster. You can give it. Let me
My
see.
lord. My lord. Similar prayer, my lord. Hearing matter, my lord. It's 23, my lord. My lord, the petitioner has passed, my lord, date, my lord, 2014.
Urgency. Why?
My lord.
Hearing matter. What is the urgency?
Last day, my lord, Mr. Mitra has mentioned before lordship, and then the lordship was directed to mention today, my lord.
What is the urgency?
My lord, the petitioner has, my lord, passed 2014 date, my lord. In as well as, my lord, the petitioner has appeared in Viva, my lord. He has passed that, but his recruitment was not considered, my lord.
I don't know these matters. This will come only after the board I have.
My lord, kindly for us to consider the mention slip.
My lord,
Please, your lordship, my lord, I beg to mention one matter. This is a hearing matter, my lord. My lord's own order was there in 16th of May 2024, directing for exchange of affidavit, my lord. Affidavits are exchanged, that is completed. Now it is ready for hearing, my lord. May it kindly be listed on any day.
It's a 2024 matter.
23rd, 23 matter.
23 matter.
My lord.
What is the issue?
But the issue is that this is regarding the appointment of a Muslim marriage registrar. I have challenged that private respondent's appointment in the post.
There's no
Lordship,
urgency. There's no urgency, sir. No, sorry.
Lordship,
I remember this matter. There's no urgency. Because this is the second round of litigation. This
Yes,
litigation had taken place earlier also. I remember it.
Lordship,
May I have your lordship's kindly to mention 2018 hearing matters, my lord. Readings are all complete.
One hearing or how many hearing matters?
My lord, there is analogous. One charge sheet common and 3 charge sheet common order of dismissal. The same act of indiscipline. So
I'll see. I'll see.
Your lordship, may I permit it one matter? It is the electricity matter. The petitioner is suffering without electricity.
Pilot?
Upgradation I'm paying for.
No upgradation.
Your lordship is urgent.
No
He is suffering
upgradation, sir.
a lot.
No upgradation.
Your lordship, without
Go and
electricity,
mention there are 2 courts. There's another court also.
it is a
No upgradation.
your lordship. My
But
senior
hearing-
was previously yesterday mentioned. Your lordship was allowed my senior, and you're directed to mention today. Your lordship.
I had already allowed this one.
Yes, your
This is the
lordship.
one.
My lord, hearing 2020-22.
Hearing
Lord, the affidavit has been exchanged.
What is the
Ready
matter?
matter. Issue is, my lord, the pay fixation on the basis of the master degree. Larger bench has been set, my lord, the past and judgment. So, my lord, law has been settled. So, my lord, only, my lord, for direction upon the authority.
My lord, may I be?
My lord, hearing matter 2019.
Review application.
What review application?
Very short issue involved में kindly
What review application? Why should the review application be listed here?
the
Review of my order.
my order, your orders, lordship orders.
Which order is that?
Lordship passed an order, my lord.
Yes.
Lordship has recorded that we have not pressed the application, my lord.
Yes.
She was granted me liberty to apply for the appropriate forum.
Yes.
So it is recorded that we have not pressed the application, my lord. Now, my lord, we have not pressed the application, my lord. That portion is, my lord.
So you're not pressing the application, you're taking it before the other appropriate forum.
My lord,
That is how it is.
That because of the obligation, the appropriate DRT, my lord, not receiving my application. My lord. They have not pressed the application before that High Court, my lord. So will not have. That is cleared apart to go before the appropriate forum. My lord, kindly, my lord, I will address all the time of the hearing. My lord, kindly, my lord, allow me to.
Maybe corporate to mention one thing. If I had mentioned this yesterday, my lord, connection by the he had mentioned earlier on procreation, so lordship had asked to come to the lordship. It's a very short matter, my lord. Petitioner is a very old person and very poor person. She's running a tea stall and she's without electricity connection for the past 1 month.
My lord, may I be permitted to mention, my lord, 2 similar and identical matter, my lord. My pension has been stopped based on a, my lord, based on
Things are
final,
complete.
my lord, inclusion, my lord, hearing matter, pleading has already been completed. My pension has been
Which year?
stopped after long retirement,
Which year?
my lord, 2023 and 4, my lord, 24.
You can wait.
May I have my lord's leave?
Wait.
I'm allowed leave to mention for inclusion of hearing matter. Pleadings are complete. This is of 2021, my lord. 2020.
What is the urgency?
Urgency is that, my lord, the matter is related to ECL, my lord. They have violated one clause for which they have withheld my retention money as well as my security deposit, my lord. And for that, my lord, they are
Money,
retention, my lord,
Retention
retention
money.
money, as well as my security deposit, my lord. And there are judgment of this honorable court, my
Your lordship, may
and
be
the pleadings are complete, my lord. It's a short issue, my lord. Don't take much time.
your lordship may be permitted to mention one matter for inclusion.
no inclusion. It can wait, madam. 22 matters. If it's old matters, I can still understand.
My lord, may I have your kind leave to mention one restoration application, my lord?
Restoration,
Restoration application of, my lord, 2020. The matter is of 2020.
restoration,
Restoration application, my lord.
who had dismissed it?
My lord,
The matter got dismissed. You're
Mat-
coming after 2020.
Uh,
After 4 years, restoration.
no, my lord, the matter was filed in 2020.
You file it, it will come in due course.
Item number 1. Item number 1, my lord, I'm for the petitioner, my lord. Mr. Shara is on his legs, my lord. I'm praying for a not today.
Not today.
Grateful.
Number 1.
Number 1.
What to do?
Not today.
My lord, one humble prayer, my lord. Can it be not this week, my lord?
Not this week. No urgency.
Item number 3.
I'm for the response of 5.
Sorry? For that matter,
Matter, related to my earlier 2 read petition was filed. This is third time.
who's appearing for the other side?
I'm for the private respondent. It's 1 of 5. Affidavit has already been extended, my lord.
What did you say?
Affidavit has already been extended by the state, and the state have already filed affidavit in opposition. I have already filed affidavit in opposition. They have filed reply, my lord, petitioner.
Nobody is here for the stay today.
Yes.
We'll have it tomorrow, not today.
Then my lord, not this week.
Not this week.
Item number 4.
My lord, I am for the petitioner, my lord. My learned advocate KBS Mohapatra is appearing in this
Where is he?
matter, my lord. He is at present in court number 33. My lord, I am praying for Passover for the day, my
No
lord.
Passover, not today.
My lord.
Not this week. We'll have it next week.
I'm grateful.
My lord.
My lord's leave.
Item number 5.
On instruction, my lord, submitted petitioner is not well, my lord, and is not make it not today.
Not this week.
Item number 6. And for the petition.
My lord, I am for the respondents. We have already filed our affidavit in opposition on the last date.
You have filed your reply to that?
But the same point has been taken and it is not required to file the reply. Same point has been taken. Now, your lordship, kindly see your lordship's order dated 25th September 2024. Your lordship. तुझे तो खाली नहीं। My lord, what happened? The father of the petitioner was an employee in a government place, binder.
Yes.
Normally, he died in 2015, my lord. His mother made an application, thereafter son made an application. Now, they issued a letter that when the vacancy will be, because since the merger is going on, when the vacancy will be available, and this letter was issued in 2018.
Yes.
When the vacancy will be available, so it will be accommodated. My lord, thereafter, my lord, I moved the writ petitions, but that court's order, page 34, but relevant page 36. I will show to your lordship. My lord, relevant page, can you see page 35
Yes, 35.
from third paragraph.
Yes.
The learned advocate relies upon the judgment of the Honorable Supreme Court delivered in the case of Sushma Ghosai and others versus Union of India, 89, volume 4, SCC 468, paragraph 8 and 9, where the Honorable Court had been pleased to hold that there should not be any delay in appointment to be made on compassionate ground. The purpose of providing appointment on compassionate ground is to be made on compassionate ground. The purpose for providing upon compassionate is to be mitigate the hardship due to death of the land bread earner in the family. Such appointments should therefore be provided immediately to redeem the family distress. If there is no suitable post for appointment, supernumerary post should be created to accommodate the applicant. The learned advocate refers to another judgment of the Honorable Supreme Court delivered in the case of Abhishek Kumar versus State of Haryana and others, reported in 2006-12 ACC, page 44, paragraph 7, where the court held that even if the post is not available at the place where the appointment is applied, applicant is applied, he has to be accommodated elsewhere where the post is available. The learned advocate appear on behalf of the respondent submit that the prayer of the petitioner is very much under active consideration as the Government of India Press is undergoing merger, public modernization and the assessment of the essential staff required to run the press is underway. Accordingly, there is no immediate vacancy where a candidate to be appointed on compassionate ground can be accommodated. It has been submitted that there are several other candidates who are in the queue to be appointed in the compassionate ground quota. As soon as the vacancy are identified for their appointment, the candidates will be informed immediately. Upon hearing the submission made on behalf of both the parties, it appeared that the father of the petitioner expired in the year 2015. The application for compassionate appointment was made for the first time 15 November 2018. The petitioner has already waited for 3 years, for making the application for compassionate appointment. Though it has been submitted that there is no time limit for making application for appointment on compassionate ground, it is incumbent upon the dependent member to make immediate application and not to wait for long 3 years for putting forward his claim. Had the family been suffering from the financial crisis, then the application for appointment ought to have been made immediately on the date of the bread earner.
The fact of this application was made after a period of 3 years implies that there was no immediate crisis for making said application. Since the government press is under process of merger or modernization and steps are being taken on assessing the requirement of the essential staff of the press and the prayer of the petition is under active consideration as submitted by the learned advocate appearing on behalf of the respondent. Accordingly, the respondent authorities are directed to consider the case for giving appointment compulsion ground to the petitioner as and when the vacancy arises, and by maintaining the serial of the applicants who have applied for being appointed on compulsion ground. The responding authority shall keep in mind the dictum passed by the Honorable Supreme Court in the matter referred to above, where the court specifically held that such application ought to be dealt with without any delay. They should be provided immediately to redeem the family distress. But this order was passed in 2019. In 18 July 2019. But thereafter, when this order was communicated, they issued a letter. But this letter, kindly see the page 45.
Yes.
I'm reading that. I am directed to refer your letter dated such and such. It is informed that the Honorable High Court disposed of this matter being WP number such and such, title Soibar Pradhan Bhasha of India on 18 July 2019 with the remark, the fact that the application was made after a period of 3 years implies that there was no immediate crisis for making the said application. Since the government press is under procedure merger or modernization and steps are being taken for assessing the requirement of the essential staff of the press and the prayer of the petition is under active consideration as submitted by the learned advocate appearing on behalf of the respondent. Accordingly, the respondent authority are directed to consider the case for giving appointment compulsion ground to the petitioner as and when the vacancy arises, and by maintaining serial of the applicant who have applied for being appointed on compulsion ground. Hence, as directed by the Honorable Court, as and when the vacancy under compulsion appointment court are available, your case for appointment will be considered by maintaining the serial number. But this was issued on 18 December 2019. And thereafter, no response. And that's why when the Honorable Court passed an order, you kindly keep in mind the dictum of the Honorable Supreme Court without causing any further delay regarding the compulsion appointment. And therefore, thereafter, I moved this present writ petitions in 2021. After waiting for 2 years, 2021. And they filed this affidavit on the same ground which has been highlighted here. Same ground. Only my prayer is how long I will be, my lord, sitting. Since 2019 to 2025, 6 years have been left. And the very dictum of the Supreme Court has been, my lord, highlighted in the judgment of the learned single judge on the earlier occasion that the delay should not be caused. But the scheme of the for compulsion.
Your affidavit doesn't answer the question which has been framed by the court.
My lord, there.
Nowhere in the, see, you know what is the problem in this matter? The problem in this matter is that you are trying to be the lawyer. The department is giving all legal answers, but not really answering the factual position. The entire dispute is only because you have said that whenever the vacancy will arise, you will grant him appointment. If the vacancy is not there, why don't you deny it? Why don't you take a decision?
Now, we have stated that unless the vacancy arises, we cannot take any step.
What do you mean the vacancy? You have to tell what is the observation from the court. See the observation of the court. The problem starts here, page 35. The learned advocate, last line.
The learned advocate appearing on behalf of the respondent submits that the prayer of the petitioner is very much under active
What do you mean
consideration.
by active consideration?
We will consider his
Why you
appointment
are not considering it? Why don't
because
you reject it?
there is no vacancy right now.
You write it. Why don't you write it?
That we have written in our opposition.
Read the affidavit now.
That is the difficulty because vacancy unless arises, we cannot give him.
Your
Kindly
affidavit in
kindly
opposition.
come to page 3 onwards. of the affidavit in opposition, last paragraph. May I place it, my lord? It is to be looked into the
Page 4, the last para.
furthermore, Directorate of Printing by its office memorandum dated informed the petitioner that as per direction of the Honorable High Court by the order dated 18 July 2019, as and when vacancies under compassionate appointment quota are available, his case for compassionate
This is
appointment.
the problem.
So thereafter, kindly come to page 5.
This is the problem, that you are not denying them the compassionate appointment. Every time you are answering that whenever the vacancy will arise, whenever the vacancy will arise.
That is the fact, my lord. Whenever the vacancy will arise, we will consider him.
So why don't you write it clearly?
My lord, that is there in page 5.
What page 5?
Page 5,
Somewhere
kindly.
you'll say that he has come after 3 years.
First,
Somewhere
that is.
you'll say, I'll consider it. The whole difficulty is the department itself keeps saying that we'll consider. Why don't you consider his representation and finish it off?
Well, unless vacancies arise,
Write it.
that we have
Give a reply to him.
that we have stated in page 5.
Your page 4, you say something. Page
Page
5,
5.
you say. Should I ignore page 4?
Page 4 is
Should I ignore page 4?
No, the question is not of ignorance. Page 4 is the submission made
By you.
by
That
the
whenever
respondent's
the
advocate.
vacancy will arise, why don't you say there's no vacancy? We can't give it.
Thereafter, what happened, that we have stated in page 5. That was in 2019, page 4. Thereafter, what happened, that we have stated in page 5.
So you file an affidavit. You file a better affidavit rather than this affidavit. And clearly say that you don't have any vacancy position and you can't consider it.
That we have stated, page 5. Kindly see, due to non-availability of vacancies for compassionate appointment.
That you have stated even in the earlier order. Have you
No,
seen that?
at present, when the affidavit has been filed, at present, it is not possible to consider anyone for appointment or compassionate appointment in GIPs.
And then after that?
The cases for compassionate appointment will be considered as per extant rules and guidelines once the vacancy become available for filling up under compassionate appointment quota.
Why don't you answer his question?
We have stated that since the vacancy.
We'll keep waiting for your vacancy to arise.
Well,
His application will be kept pending. Why don't you decide the application of this gentleman?
Well, we will decide that. We will decide.
The application.
Decide that. We will decide. Kindly direct us to decide that.
Well, only one thing. Only one thing. You also kindly pass an order that since the vacancy from 2019 to 2025, the vacancy is not available. That is for long 5 years. But nobody can say when the vacancy will be available.
So this is not a matter of right. First of all, you have
not
come
a matter of right. But when the authority has said there must be a vacancy, some vacancy it will be arising.
This vacancy, they'll consider you.
Yes, but
they don't have any vacancy. That's
that
what
is,
they are saying.
No, that's why I'm making the submission that from 2019 to 2025, no vacancy is available. As per their statement.
Take down.
If that be so, then
you want to file a reply to this?
My lord?
You want to file your reply to this?
Then
you want to file your reply to the affidavit in opposition?
Then I have to give this reply.
Give a reply.
Or you also alternatively pass that order. I want to.
No, you give the reply. If I pass the order, you'll be aggrieved.
Dispose it of.
Okay, you also can be disposed. The matter can.
I'll dispose it off, sir.
Kali hear me 2 minutes time.
I'll dispose it off.
I understand.
If you want to file your reply, you tell me. Otherwise, I'll dispose it off. I have no problem in disposing it off.
I understand. What's your list of losses?
Your case is not that good. Let me tell you very frankly. So you want to file your reply, you tell me, or I'll dispose it off.
Then I will give this reply.
The person died in 2015. You make the application in 2018. There's a delay of 3 years. These are compassionate appointment is only to harness the financial emergency of a person.
Even these
are not anywhere. You want to file it?
Only one thing. Yes, I will file the reply. Only after the observation recorded, is delay. Thereafter, Lane Singh pass this order. You file the, you consider this application taken into the note of the decision of the Supreme Court.
Seeks time to file his reply to the affidavit in opposition within a period of how much time?
2 weeks. 2 weeks.
2 weeks. Let this matter be listed after 4 weeks.
4 weeks.
And in the meantime, he has made an application. Decide the application. Send it to him.
My lord. I shall give proper advice to them.
Don't blow hot and cold at the same time.
My lord. 2015 person died.
Why don't you decide it?
And we are in 2025.
Is anybody stopping you?
This is not a financial
Is anybody
intelligence.
stopping you from deciding the application? You
No, no,
only
certain-
keep writing all this. Extent rules, vacancy position will arise, then we will consider. Why do you have to write all that? Why can't you decide the application? Entire controversy is because of you.
My lord, I shall take proper steps. I shall advise them to take proper
But this
steps.
submission was made before the learned single on the earlier occasion regarding delay. But in spite of having that submission, the learned single judge passed this order. You consider the applications keeping in view of the decision of the Honorable
What
Supreme
steps
Court.
he has taken to hear out the writ petition
I'm
of
not getting into it.
2021?
No, I have taken the step. This
4 years he has
File your
not taken
reply.
steps.
I will file the reply.
I am
And you
grateful.
decide the application, the matter will be over.
I am grateful.
You have to just write 2 lines to him. Still, you are not writing it. You have to just tell the vacancy position as of today. He's not entitled, he's not entitled.
My lord, I shall.
Next.
Grateful.
Item number 7.
My lord, in item 7, my lord, Mr. Caldwell Basu is appearing in this matter. His mother has taken ill, my lord. He's not come to court. If it could
Not
be
this
made
week.
known. Grateful, my lord.
Item number 9.
My lord, item 9, similar prayer, my lord, as item 7, Mr. Grateful, my lord.
Item number 10.
For the respondent, led by Mr. Shobik Nandi.
Yesterday also nobody was here, huh?
My lord, on the last occasion, my lord had directed supplementary affidavit to be. We haven't.
You appeared for the petition?
We
That
have.
I am appearing for the
Yes.
petition, my lord. I'm praying for not today, my lord.
Huh?
Praying for not today, my lord.
Why? You were supposed to file affidavit also?
Yes, my lord, learned conducting senior advocate of this matter is not available today. As such, I'm praying before your lordship make
Not
it
this
not.
week.
Wait.
This week. Item number 11.
Your lordship's order, my lord, has been communicated to the state. But I've communicated your lordship's order to the state.
You know it. We can't decide this matter without it.
That's very true. My lord, the mission is absolutely with us. The mission says we are entitled to the.
The mission, I know mission is with you, but that will not help. Unless until the government decides, and the money has to come from the government, not from the mission.
Lordship. Lordship would pass an order upon the state, my lord, so that we can communicate, and the next state, my lord, we can ensure their presence.
Take down, sir. This court-wide order dated 13/2/2025 had shown its displeasure on the ground that there has been no appearance on behalf of the state in the present matter. This writ petition pertains to the year
2023.
2023. Till date, no affidavit in opposition has been filed on behalf of the state. Despite the previous order being communicated to the office of the learned government pleader, High Court at Calcutta, no appearance is there on behalf of the government. Let fresh notice be issued and a copy of this order be communicated to the office of the learned government pleader, showing the displeasure expressed by this court despite repeated request for the state to appear in this matter and file their affidavit in opposition.
But I'm
Let
grateful.
this matter be listed after a week.
Copy that.
After 1 week.
After 1 week. Grateful.
Item number 12.
Take down. None appears for the petitioner. On earlier occasion, i.e. 24/9/2024, as well as on 6/12/2024, there has been no appearance on behalf of the petitioner. Full stop. It seems the petitioner is not interested in pursuing the present writ petition. The same is dismissed and deferred.
Item number 14.
And for the petitioner, my lord. Well, earlier occasion, my lord, Lordship directed the electricity authority, my lord, to submit whether the final assessment bill has been passed or not.
Yes, Mr.
Yes.
My lord.
In pursuance to your lordship direction, I have taken instructions. It's a matter of 2009. Your lordship will find that so far the provisional assessment has been concerned, it has been passed. But since no objection has been taken out, no final order of assessment has been made as yet, Marshal. If a lordship direct, then we can file, let them file the written objection. On that pretext, we will file the, we'll take the final assessment order, lordship.
Then you give them the opportunity.
Yes, certainly, certainly. And your lordship knows, but I'm not going into that since lordship has not put that question. Even if the final order of assessment has not been passed, subsequently, if the opportunity has been granted to them, then the final order of assessment can be passed in pursuant to the division bench order. There is a specific division bench order also. But it doesn't taken away. But since your lordship is saying that the final opportunity should be given to them, no issue.
Learned counsel for the respondent very fairly states that no final assessment order has been passed by the authority under section 126 of the Electricity Act. Learned counsel for the respondent states that they shall decide. The petitioner is entitled to file an objection, and the same shall be decided by the authority concerned within a period of 2 weeks.
30 days may be given subject to
The learned counsel for the petitioner states that he shall file an objection within a period of
2 weeks.
Within a period of 2 weeks. The same shall be decided by the respondent authority within a period of 4 weeks thereafter.
Lordship.
In view of the same, the present writ petition is disposed of by giving the liberty to the petitioner to file his objection before the concerned authority, and the authority shall pass the final assessment order in terms of section 126 of the Electricity Act 2003.
Kindly record that in default, the final order of assessment will be passed if no objection has been filed within a period of 2 weeks, lordship. In default,
it is made clear that if the petitioner fails to file his written objection within a period of 2 weeks, it shall be assumed that the authority concerned shall be at liberty to pass the final assessment order ex parte.
I'm deeply obliged.
Item number 15.
Item number 15, I am for the state.
I appear on behalf of the CAC in this matter.
Lordship, with the above direction, this writ petition is disposed of. With the above direction, yes, sir.
Lordship, this is my application.
Yes.
I have come up before your lordships for getting new electric connection.
Yes.
As it has been communicated by the CSC Limited that the private respondent is raising objection.
Yes.
On the last occasion, your lordship, the CSC, the licensing authority has handed over a letter before your lordship to demonstrate that there is a split load. Splitting of load.
We have
on
inspected, my lord,
29
and we have found that.
May I be permitted to submit my? Yes. On 29 September 2023, one letter has been issued by the licensing authority that I want to split the load by getting the new electric connection. Now, your lordships, I am drawing only 2 dates, subject to your lordship's kind permission. According to them, on 29 September 2023,
Where's the letter?
they have submitted, your lordship.
May I hand over a copy?
Yeah, I have.
Lordship. Just now I have got it submitted by my last. On 29 September 2023, they have issued the letter according to them, according to the inspection carried out on 28 September 2023. Now, your lordship, October 2023, I have deposited a bill on account of erstwhile consumer for an outstanding amount. On 16th October 2023, your lordship, your lordships kindly see page number 16. 16. It has been sent by special messenger by the licensing authority, which prompted me to come before your lordship, that the private respondent, Mrs. KB Syndicate Private Limited, is raising the objection. Page number 16, your lordship's got it. 16th October 2023, this is the letter issued by the CSC Limited. And the objection is at page number 17. Now, if that be the case of the speed load, your lordships, certainly I will not trouble your lordships, but because my remedy is before the grievance redressal officer, your lordship. But here, the case is otherwise, because the private respondent is raising objection as per the licensing authority. Now, so far as my occupation is concerned, I have given the documents, but as the objection raised by the licensing authority with regard to the speed load, that's why I have placed these 3 dates before your lordships, because this letter, this 29 September 2023 letter has been issued prior. The 16th October 2023 letter has been issued afterwards.
The 16th is only with reference to your application for supply and our subsequent inspection, and above we are enclosing letter dated 7/10/2023.
Lordship.
From KB Syndicate. This
Sir,
is the
we have
response.
just forwarded the letter to my learned friend.
You are not going to work on private parties.
Manat?
You're not going to work on the instruction
No,
of
we
private
have
parties.
not.
You have to do
Manat,
your own
what has
inspection.
happened? No, Manat, what has happened? He has made for an application for new meter.
Yes.
We have inspected.
Yes.
We have found that there is a splitting of load. We have issued the letter on 29. Subsequently, my lord, we have received this objection from the landlord.
Yes.
So it is our duty, my lord, to forward him a copy. We have forwarded through letter dated 16/10.
Right.
But that's all we have done. We have done nothing more. We have never stated that it is not a case of splitting of load.
The splitting of loads, you don't give connection.
No, my lord, according to regulation 14, my lord, he has to go before the GR. When this is the division bench judgment, my lord.
I am bound to your lordships. I am not on that, because if that be the so, I have to go before the grievance redressal, because that is the remedy lies.
That's
but
what,
here, your lordships, the case is different.
No, it's not different. It's not different.
The the private respondent is raising objection.
No,
That is the communication
they are-
by the
You
CS
forget that
Limited.
conversation. That is a subsequent one. This 29/9, this which you have received, this is on the basis of splitting of loads.
Lordship, there are much, I should not, but
Yes.
from whom I am getting the connection? That is not there.
No, that will be decided by the GRO, my lord. We have rejected in the ground of, my lord, splitting in respect of
I
regulation.
have no connection over there, and this is a private limited. This is a not residential that I am getting my supply from the.
See, they are very clear. You have to go before the GR.
No, Lordship, so far as the splitting of load
You
is
have to go before.
I have to. I have
to go before the GRO. You don't need to speak anything.
One thing I need to.
No need. No need. You go before the GRO.
Only your lordships, as this is a matter of pending, your lordships kindly make a time frame so that I can get my electricity. It's a private limited company, and without the electricity, your
But
lordships
GRO
can.
must be deciding the issues
Yes,
in a
yes.
time-bound manner.
Yes, as your lordship.
They must be deciding in a time-bound manner.
Lordship, kindly time make it done.
So what is generally the time frame in which the applications are decided before the GRO?
No, it's generally 4 weeks, my lord, that they take.
4 weeks? No, there's no need to pass an order to that extent. They will be deciding the application.
Your lordships, this is a huge number of matter is pending before
My
your
lord can, my
lordships.
lord, there is no problem.
Nowadays, it is a common practice.
Learned counsel for the petitioner seeks to withdraw the present writ petition, seeking liberty to approach the GRO. Full stop. Since the petitioner, liberty is granted to the petitioner to approach the GRO. Full stop. The GRO shall decide the application of the petitioner expeditiously, preferably within a period of 6 weeks from the date of communication of this order. The petitioner shall communicate the order.
My lord, only thing, my lord, if my lord may kindly, at subject to your lordship, kind permission that upon hearing both the parties concerned.
वो छोड़ दो आप. The GRO shall decide the application after affording an opportunity of hearing to all the interested parties.
Good. I'm grateful.
With the above direction, the present writ petition is disposed of. To seek his remedy before the GRO, grievance redressal officer. Full stop. Liberty is granted to the petitioner.
Great.
নিচে নাম দিয়েছে সবাই
Item number 17.
My lord, in item number 17, I appeal
I
on the
appeal
behalf
on
of the
the
private
petitioner.
respondent.
My lord, this is an application for new connection, my lord, on the my lord, application for new connection, my lord, due to the objection raised by the private respondent, my lord, the licensing authority could not give the connection, my lord, and
yes,
I have admittedly I am in possession, my lord.
My lord,
We'll have it tomorrow.
may I
Tomorrow,
submit, my lord, the matter can be dismissed here and now, your lordship. My lord,
Yes, it will be dismissed against you. Don't worry.
No, we are ready and willing to give them a no objection certificate, my lord. They can install the meter. We don't have any problem with that.
What is the difficulty then?
My lord, they are
Initially,
coming.
my lord, initially there was a dispute, my lord. Subsequently, the dispute has been resolved. My lord can dismiss the writ petition, lordship.
No, may not be dismissed, my lord. Let that be disposed with that order, my lord. Let it be disposed.
Let it be disposed with an order, lordship.
Yes.
And
Yes. Let the instruction come. He doesn't have any instruction.
only one day.
Tomorrow.
Much obliged.
not today Item number 22.
May I please the Lordship? I'm appearing on behalf of the petitioner in this matter. Your Lordship, this was a tender matter which we had filed in October 24. Now, because the petition has become infructuous, we pray to your Lordship we may be allowed to withdraw the said petition.
Learned counsel for the petitioner seeks to withdraw the present writ petition.
Liberty to take steps in accordance
The
with law.
same has become infructuous. Present writ petition is dismissed and withdrawn.
বলো ভিজিতে ছিল item number 24.
The mic is for the.
You give your appearance. Give your appearance.
Item number 24.
You're in 24. None for the petitioner. In the interest of justice, adverse orders are deferred. List after a week. Adverse orders are deferred. List after 1 week. Don't want to dismiss.
না ভিজিতে যিনি ছিলেন 18 হ্যাঁ Item number 32.
32, I am for the petitioner, my lord. Last occasion, your lordship directed me to take instruction, my lord, because my lord, I have, it is my commercial connection of the petitioner. Petitioner, very poor person, my lord. He has applied for quotation money was deposited, but they have my lord, told my lord, quotation money was deposited. Thereafter, my lord, they have told my lord, they have purchased my lord, the transformer, my lord. But my client, if your lordship, my lord, consider it, my lord, he is a poor farmer, poor person, my lord. He purchased the land and constructed that for business purpose, my lord. He has no money, my lord. So, my lord, your lordship, they give the connection, the existing transformer, my lord. So, my lord, I will be obliged, my lord.
My lord, on last occasion, I have submitted the instruction along with the letter that the connection is not techno-economically feasible. It is commercial connection. If they are ready and willing to pay the charges for the transformer installation charges, we are ready to provide the
Transformer, how can they get the connection?
Then I will give my lord.
There is no
Want to
basic
withdraw it?
infrastructure in that
No,
area.
not withdraw, my lord. I paid, my lord. They will expedite. My lord,
All right, then I'll keep it after 2 weeks. You make the payment.
If they are willing to pay the.
pass some order, my lord. Otherwise, they will not.
So why should I pass an order against you? I have given you time to seek instruction whether you are ready to pay.
Yes, my lord. I will pay, my lord, but your lordship pass the order, my lord. Necessary order, my lord. So that
You pay the money, come here, I'll pass an order. Make the payment. I'll pass an order.
And then your lordship adjourn 2 weeks, my lord. 2 weeks. 2 weeks, my lord.
The lordship may direct us to give issue a quotation.
Issue, yes, my lord. They will issue a quotation, then my lord. I will
issue a quotation and they.
You issue a quotation. Learned counsel with the petitioner seeks 2 weeks time. Learned counsel for the respondent submits that he will issue a quotation regarding the payment to be made for installation of
new
transformer. Learned counsel for the petitioner seeks further time of 2 weeks to make the said payment. Full stop. Let this matter be listed after 2 weeks.
My lord, I bless you.
Item number 33.
I am appearing for the license.
on affidavit service. My lord, this is the, my lord, second round litigation, my lord. Petitioner submitted several representations and demanded justice. My lord, that was considered only, my lord, kindly see the consideration, my lord, last page, my lord, page 26, my lord.
Page
26. P8.
26.
Yes, my lord. This is to inform you that we have received a photocopy of the above mentioned order dated such and such pit post. We have already completed all work from our end, and transformer was installed on 18/6/2024 after harvesting got completed in the country. But this is not the grievance only, not only the grievance, my lord. Kindly page 22, my lord. Demand justice, my lord. Page 22. But several complaints, my lord, that there was no infrastructure that has been completed by my lord, installing a separate transformer. That is correct, my lord. But my lord, the private respondent is shifting his my lord submersible pump from one person to another person without any permission, and just beside my submersible pump, my lord. My lord, for installing a submersible pump, there must be a
This is not a public interest litigation, sir. What is your dispute? What do you want?
not only
This
that,
is
my
not
lord.
public
They
interest
are
litigation.
they are now demanding money, huge amount, my lord, for the long years, my lord. That was not possible.
Where is your application which you have asked for the connection? Where's your application?
Application of my lord, demand justice, my lord, and page 23. 23 Karthik Chandra Paul, that is my another person, my lord, that is not. My lord, page 16, page 16 also demand justice, and thereafter, my lord, page 17, my lord, আমার কনজিউমার আইডি নম্বর অধীনে বিনীত নিবেদন, এই যে আমি সন্ন্যাসী পাল অন্তর্গত কিন্তু বাসিন্দা কনজিউমার নম্বর আজ পর্যন্ত আমার এলাকার মিটার অকেজো হয়ে আছে, কিন্তু আমার 2,762 টাকা 60 পয়সা, আমি খুব চিন্তায় পড়ে গেছি, আমার সাবমার্সিবলটি চলে নাই, মানে হি ইজ নট রানিং, আমি বিল কিভাবে পরিশোধ করিব?
So you have come here against respond number 4.
Yes.
Kindly,
what is your problem with respond number 4?
Respondent 4, my lord, is shifting his submersible pump from a long distance from my submersible pump, and he is now installing just beside my, where he is not the owner.
If they are entitled, they will do it. You don't have to look into that aspect. That is for the LCD company to look into it, whether they are entitled for the connection or not.
My lord, kindly direct any other higher authority to consider my grievance, all grievance. Any higher authority, my lord.
Grievances.
My lord,
sorry
to say, my lord, I personally visit this is my visit these premises, my lord. One day, my lord, when
Why should I get involved in your personal grievances?
my lord, kindly any higher authority, my lord.
Yeah, but why should I get into it?
My lord, there are several disputes, my lord, regarding the installation of the private respondent's submersible pump. I have served upon him also. He is not coming.
Kindly come to page 22. This is the
Yes.
letter of the advocate of the petitioner.
Yes, my lord.
What he asked for. It is unfortunate a poor farmer who is trying to survive himself in these hard days when natural source of water is not sufficient to cultivate the land of the locality, for which my client had to operate submersible pump. But since the inception, the said submersible pump, the distribution company behaving like a stepmother, because no specifically alleged that without supplying power, infrastructure regularly bill are being supplied, they are allowing the Tomal Krishna Pal, son of late so and so, the same village,
shifting the submersible pump whimsically, how the licensee will do in respect of someone is shifting the submersible pump in his plot. The civil may go to the.
No, civil no dispute. Shifting.
We are concerned giving the.
He is not the owner, he is shifting. One place that will be that submersible pump will be installed in a particular place, and that particular place will be mentioned in the application. Kindly direct them to produce the record where the submersible pump has been permitted of Tamal Krishna Pal.
Have you served him? Respond number 4. Service has been effected.
Service completed.
What is this you have filed? What is
service?
this?
Service, my lord.
No, this. Where's the affidavit of service? Where's the affidavit of service?
Oh, no, my lord, this is not. Sorry, my lord. Sorry, this has been. Oh, sorry, my lord.
কি চাইছো বলে তো তোমার চাওয়াটা কি?
চাইছে মানে ওইটুখানি ওই রেসপন্স ফোর্স যাতে আমাকে ইয়ে না করতে পারে আর কি, যেখানে সেখানে ইয়ে পাম্প মেশিন চালাচ্ছে আর কি, 5টা মোটর চালায় একটা ইয়েতে, একটা এই কানেকশনে 5টা মোটর চালায়।
Earlier, there was an order which was passed on 21st May.
Yes, my
to
lord.
consider his representation.
Yes, my lord.
Did they consider it?
Last page, my lord, 26. This is the consideration. Only some one, my lord, transformer has been installed. That is the consideration. No reason order, nothing.
Then, my lord, I have to take, because that letter does not show. That letter says that this is to inform you that we have received the photocopy of the above mentioned order on 27/8/2024 through this speed post, that we have already completed all work from your end. From our end, and transformer was installed on so and so. After Hajmishki got completed, the function feed in service connection of Submersible is compliance to the above mentioned order.
Take down. Learned counsel of the petitioner has preferred the present writ petition, seeking direction against respondent number 4 for operating his submersible pump illegally and for frequently shifting the pump and shifting the motor to different places. Full stop. This court-wide order dated 21st May 2024 in writ petition number 28924 of 2023 had given direction to the respondent to decide petitioner's representation. Full stop. In view of the said direction, learned counsel for the petitioner states that he has received a communication dated 28/8/2024, wherein wherein the respondent had stated that they have completed all work from their end and the transformer has been installed on 18/6/2024 after harvesting got completed in the concerned field against service connection of Sannyasi Pal in compliance of the above mentioned order. Full stop. In terms of the said speaking order, nothing survives in the present writ petition. The learned counsel of the petitioner is filing this frivolous petition wherein he is aggrieved by connection granted to a third party, i.e. Tamal Krishan Pal, full stop. Learned counsel for the respondent states that no illegal connection has been granted to respond number 4 and that he is running his said submersible pump in accordance with law. Full stop. This is not a public interest litigation. Nothing survives in the present writ petition. The same is dismissed.
My lord, kindly rescind order, shall bear this.
Challenge it, challenge it. Challenge the order. Next.
Item number 34. I am for the petition, Lordship.
Yes.
Lordship, that matter, petition I applied for sub.
Matter heard on
Yes, yes.
26th of February 2025, my lord.
Yes.
Lordship, I have
Mother-in-law already has a connection.
No, I'm submitting, Lordship. I have taken instruction, Lordship. The mother-in-law's connection was related to different moja, different dark number, and petitioners and taking connection at different moja and different. This is my instruction, and I have already with me the suit certificate of the mother-in-law, the SW.
Learned counsel for the take Learned counsel for the petitioner states. Yes, I'll give you time. I'll give you time to file reply.
My lord, if my lord in this
Lordship.
matter, my lord,
Yes.
if the BLR may be the party in this matter, my lord, then my lord, he can, my lord, assess, my lord, what moja, what dag number. It is
file-
difficult for us, my lord, to my lord, what is the
file
dag
your-
number.
File your reply. File your reply.
Lordship,
Learned
they will
counsel for the
file
petitioner-
affidavit opposition.
Learned counsel for the petitioner states that his mother-in-law is residing in a separate Mauza.
Lordship, this is not residential connection. This is connection for submersible pump.
Yes. Submersible pump?
Yes.
The submersible
Huge
pump
amount
also
of
has
use,
to be
Mara.
in some area.
Yes, different moja, different dark number.
Yes. In a different Mauza and a different Dag. And that the petitioner has applied for the new connection in a different Mauja and a different Dag.
Lordship.
Full stop. The said fact is disputed by the learned counsel for the respondent. Let an affidavit in opposition be filed by the learned counsel for the respondent. Seeks 2 weeks time to file an
3
affidavit.
weeks, my lord.
3 weeks time to file an affidavit in opposition. Reply to the same within a period of
10 days, Lordship.
1 week thereafter. List after 4 weeks.
Grateful, Lordship.
My lord, he has not, my lord, he has not disclosed, my lord, what moja, what
Yes,
dag
yes,
number.
I can.
Nothing, my lord, disclosed to me,
I
my
can-
lord.
I
Was
can-
He
not-
will come to you. You write a letter to him.
My lord.
Why don't you write a letter to him? He'll give you. See,
Then, my
when-
lord, they will give me, my lord, 4 weeks time, my lord, because my lord will give him a letter, my lord. Then, my lord, he will reply, my lord.
3 weeks time. You write. You put it in the affidavit. He has not given any information. You are not providing him. Finished.
Lordship, first of all,
Let him give all information. to
after
you.
my application, they have not communicated anything to us.
That you have to do. Decide
Nothing,
on the
Lordship.
application.
During hearing, they are disclosing this is the fact, Lordship.
So you decide his application. If you're not giving it, not giving it. But decide it.
Item number 35.
35, I am for the petitioner, my lord, kind affidavit of service.
I am applying for the CSP respondent.
My lord, kindly see in paragraph 4, page 4, paragraph 4. that your petitioner said that petitioner made an application for supply of electricity on 28th May 2024, and such application was accepted and raised the quotation dated 6/6/2024. It was duly submitted the petitioner in terms of the raised bill. Kindly see, my lord, page 19, my lord. Page 19. Request for new connection of submission all documents, my lord. I have already paid the amount, my lord. Next page, page 20, my lord.
Yes, you have already raised.
Kindly come to next paragraph, paragraph 5.
Where?
Petitioner, page 4, paragraph 5. 2 occasions we went for giving him new connection, but main dispute is between the private respondent and the petitioners, because we are restrained from giving the connections. He himself stated in paragraph 5. Civil suit is pending, criminal case is pending.
New
Main
connection
dispute is pending between them, my lord.
Well, I have already quoted the amount, my lord. 23.
Yes, we have received the quotation money, my lord.
Yes, my lord. Page 20.
What are the civil disputes pending between you?
Private respondents are objection for new connection, my lord. This is the dispute.
Service
You have served them?
All sorry.
Service has been affected?
Yes.
How many respondents are there, private respondents?
Respondents are, my lord, 8.
Total 8.
Total 8, my lord.
After 4, there are private respondent, my lord. 5, 6, 7, 8. 4 private respondent.
Just see if the service has been done. Dekna, service हुआ है. Check the service. Private respondent.
Laltu Molda.
Laltu Molda.
Laltu.
Yunus Ali Molda. Yunus Ali Molda.
Lalo
Molda.
District engineer, district engineer.
এইখানে দেখো এই যে ট্র্যাক অ্যাসাইনমেন্ট
Deliver confirm.
ডেলিভার কনফার্ম ডাউন ডেলিভার কনফার্ম এটা হচ্ছে
So if the police protection is given to you, you can grant it. Service done. Affidavit of service is taken on record. Learned counsel for the petition is aggrieved by the non-grant of electricity connection to the petitioner's premises. Full stop. It is the case of the petitioner that he applied for a new electricity connection by application dated 25/2024 and had deposited the quotation amount on 6/6/2024. Full stop. The respondent authority tried to effect the electricity connection on 19/6/2024.
2 occasions, my lord.
Full stop. On 2 occasions.
19/6 and
19/6 and
August 2, 2024.
2nd August 2024. However, due to obstruction raised by the private respondents, the electricity connection could not be effected. Full stop. The petitioner filed a complaint before Zinzira Bazar Inspector in Charge, Mahesh Tala Police Station, by GD number 632 dated 26/24/24, full stop. Thereafter, the petitioner approached the concerned subdivisional magistrate under section 144 CRPC, being MP case number 2264 of 2024, full stop. Wide order dated 21/6/2024. The subdivisional magistrate directed the parties to maintain peace and tranquility in the area, full stop. Being agreed by the inaction of the respondent authority, the petitioner has preferred the presented petition. Learned counsel for the respondent submits that they are willing to restore respondent B WS CSC. CSC submits that they are willing to grant the electricity connection provided adequate police protection is provided to them, full stop. In view of the same, the respondents are directed to grant the electricity connection to the petitioner with the, in view of the same, let the, who's the officer in charge, which is the area?
Officer in charge, my lord.
Jinjira police station.
Jinjira police
In
station.
view of the same,
Yes,
this court directs the officer in charge, Jinjara Bazaar
Jinjira
Police Station,
my lord.
Mahesh Tala Police Station.
Mohestola.
My lord.
Yes, my lord, Mohestola police station.
Under Mohestola police station.
Under Mahesh Tala Police
yes,
Station to provide adequate police protection to the respondent authority CSC. Full stop. The respondent authority along with the cost of the same shall be borne by the petitioner.
My lord.
The respondent authority along with the assistance of the police personnel shall effect electricity connection on the premises of the petitioner within a period of
2 weeks.
Within a period of 2 weeks
From the date of
since the
compliance.
passing of
Yes, yes.
passing of this order.
Yes. Dispose of.
With the above direction, the presented petition is disposed of.
Police station.
Now,
IC Mohestola police station.
Under Mohestola.
Under Mohestola police station. হ্যাঁ
হুম।
ওটা হচ্ছে ফাঁড়ি এটা হচ্ছে আর এটা হচ্ছে
মন্ডলপাড়া, হ্যাঁ। Grateful, my lord. Item number 36.
And I appear on behalf of for the petitioner, my lord. His yield, my lord. Please give
Not the same.
Item number 37.
But I am for the petitioner. I am a tenant under my lord private respondent number, my lord 5 and 6. I, my lord, applied for fresh meter, my lord.
Applied for a?
I have applied for fresh connection in my tenancy, my lord. My lord, in terms of that application, my lord, CSC, my lord, asked me to pay, my lord, something, my lord, that is 1,88,453, that which I deposited, my lord, page 25, annexed P5.
Is this order not appealable?
My lord, a third party.
I beg your pardon.
The order not appealable before the
My lord, what has happened, my lord? He has
water.
My lord, he has made an application for new service connection. We has attempted twice, my lord. We have been registered by the inmates, my lord. My lord, grant me police protection and give me 4 weeks time, my lord. We will implement.
My lord, kindly say person, my lord.
And only thing, my lord, if any other compliances he has to make, he will make, and subsequent to that, within 4
I
weeks
have
we will-
deposited, my lord, that amount which I have been asked for, my lord. I am ready and willing to pay all other formalities and payment, all sorts of payment. This is my commercial venture. I am not in a position to utilize my lord tenancy, my lord. So, my lord, a third party, my lord, respondent number 4, who is nobody. My landlord consenting me. My lord, I have annexed, my lord, rent receipt. I have annexed, my lord, tenancy agreement. My landlord has no objection. But a third party raising objection, he flexing his muscle. So that for that reason, CSC is not in the. My lord, kindly direct, my lord, with the help of police.
Petitioner has preferred the present
police station.
petition being aggrieved by non-grant of electricity connection by the respondent authority qua the petitioner's tenanted premises, i.e. premises number 5/5/1 Cholpati Road, Police Station, Beliagata, Kolkata. Full stop. Learned counsel, the petitioner submits that the premises in question is government khas land, comma, owned and possessed by the state of West Bengal, full stop. Further, the state of West Bengal has executed a lease deed in favor of respondent number 4 and one Mr. Kunal Das, full stop. Mr. Kunal Das, during his lifetime, executed a lease deed in favor of the petitioner and inducted him in the premises in question, full stop. Mr. Kunal Das expired on 16/4/2024, full stop. Thereafter, the legal heirs of Mr. Das executed a lease agreement in favor of the petitioner and accepted the rent, full stop. Learned counsel for the petitioner submits that the petitioner is paying a monthly rent of rupees 8,000 to the legal heirs of late Kunal Das, full stop. The petitioner applied for the commercial electricity connection for the premises in question in the month of July 2024 and deposited the quotation amount of rupees 1,88,453 towards the installation charges, full stop. The respondent could not grant the electricity connection due to the objections raised by respondent number 4, full stop. The petitioner preferred an application under section 163 of BNSS before the executive magistrate Sialda, being MP case number 1045 of 2024, full stop. The learned executive magistrate directed the police authorities to file a status report and also to maintain peace in the said locality, full stop. Being aggrieved by the inaction of the respondent WB CSC Limited in not granting the city connection, the petitioner has preferred the present writ petition, full stop. Learned counsel for the respondent submits that they are willing to grant the LCT connection.
New service connection.
New service connection, provided adequate police protection is provided to them.
For laying, whenever we kindly add, subject to your lordship permission, to laying down the cables, but this is a new service connection, we have to lay down.
Service connection will take care of that in providing the LCT connection. In view of the same, the present writ petition is disposed of by directing the
petition
OC, which police station? Beliagata police station.
Respondent number, my lord, 3. Officer in jail, respondent number 3, Beliagata police.
Respondent number 3, yeah, Beliagata police, OC Beliagata police station, to provide adequate police protection to the respondent CSC in providing the service connection to the petitioner. The cost of the same shall be borne by the petitioner, full stop. It is further the petitioner states that they shall comply with all the necessary requirements as enumerated in law. With the above direction, the present writ petition is disposed of.
The affidavit of service, my lord.
The affidavit of service is taken on record.
My landlord also appeared, my lord.
Give your appearance.
5-6, deeply obliged.
Great.
Item number 38.
For the petitioner, after filing the writ petition, my lord, the electricity connection has been effected to the writ petitioner, so I am not pressing that.
Learned counsel, the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn. Give your appearance. Dismissed as withdrawn. इसको एक ऐसे कर लो. Since the petitioner has already been, since the grievance of petitioner has already been addressed by grant of an electricity connection, the present writ petition has become infructuous. The petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn. ठीक है? Dismissed as withdrawn.
Item number 39, my lord, in this matter, I am appearing for the petitioner. I applied for giving the connection in respect of submersible pump, and quotation has been given by the distribution company, and I complied with. As per the quotation, I deposited the money, and after filing this REIT application, they have already given the connection. So this matter, my lord, is already.
Same order
I have no
qualification.
objection. If it is.
Same
My
order,
understanding
same
is
order.
applied.
No, since the petition has already.
Yes, that the observation, my lord.
Yes.
Otherwise, these matters should not be dismissed. That
ऊपर लिखा है ना, since the electricity connection has already, since the petition is already, his grievance has already been.
already given connection in respect of submersible pump and my land during pendency of this.
Therefore, he has no claim.
Oh, yes, definitely. After giving the connection, what claim? That's the sender before this court. Develop.
Yeah, affidavit itself.
Item number 40.
Worship, I am for the petitioner.
On the 40, I appear on behalf of the CS.
Yes.
I have applied for the electricity connection. The private respondent who is happened to be my sister, according to my instruction, the respondent number 3 is raising objection.
Yes, sir.
So that as per my instruction, there is a splitting of load, my lord. And one more thing, my lord, I have just gathered, my lord, that the petitioner has approached the District Consumer Redressal Commission, my lord, wherein an order has been passed that the matter should be referred to GR. I don't have the order right now, but it is, well, it is an order.
We'll keep it next week. Next week?
Next week, Your Lordship. Your Lordship, next week, Your Lordship, I have to take instruction whether my learned
When do you
friend.
want it? You tell me. When do you want? Next, that's what I said, next week.
Petitioner.
Not this week. Not this week.
Not this.
The learned counsel, the respondent submits that the petitioner has approached the Consumer Redressal Grievance Commission, and there has been a direction passed by the Consumer Grievance Redressal Commission, wherein the petitioner has been given the liberty to approach the GRO.
Yeah. No, that is on instruction I am submitting, my lord.
On instruction, learned counsel, the respondent submits. Full stop. Learned counsel, the petitioner states that he is not aware of any such development. He seeks 1 week time to take instruction regarding this.
Good. I'm
Let
grateful.
this matter be listed next week. GR. The Grievance Redressal Office. Bracket में डाल देना Grievance Redressal.
But I am very grateful because in
I am on behalf of the petitioner.
item 22, though I was not present, my name has been recorded. Lord, I am extremely grateful, Lordship. Yesterday that was.
I told.
I am grateful, Lordship.
In that matter, I am for the petitioner. Petitioner, before your lordship,
we'll have it after lunch.
Submit an application for domestic connection of his house.
41.
And on the basis of the said application, he submit application on the first week of December 2015. And on the basis of the said application, quotation issued on 16 December 2015, which is as page 12, P1. On the basis of the said quotation, petitioner had already deposited the quotation amount, which is at next page, page 13. But thereafter,
Did you
petitioner.
deposit the money before the appellate authority?
Yes, my lord.
Did you deposit the money in terms of section 127 before the 127(2)?
Thereafter, after deposit of the quotation amount, there is no intimation. Petitioner went at the office of the concerned respondent, which is as I have stated in page 4, paragraph 5. In the
Sir, you approached the appellate authority, right?
Yes, appellate authority. My lord, thereafter, the worker before the electricity department, when they change the cable line, petitioner shown them the quotation amount deposited. They connected the line and also directed to go to the office of the concerned respondent. Petitioner went more or less 6 times before the station manager.
Mr. Nayak, what is it?
My lord, page 14. Worship.
Page?
It's a case of theft because random, my lord, theft by hooking was conducted by him.
Yes.
And my lord, page 14, every explanation has been given. Final assessment has been made to the tune of rupees 1,568. So neither any appeal.
As
that
the
has to be-
quotation amount deposited, it is the duty of the licensing company to provide the electricity by installing the meter, but they did not. What the section 43 subsection 3 says, Lordship, kindly see.
We'll see it after lunch. I'm not feeling too well. I don't know if I'll sit after lunch or not.
Grateful, Lordship.